What if I told you that the Supreme Court just made a ruling so unexpected, so unbalanced, that even the most seasoned constitutional lawyers didn't see it coming? An 8-1 decision that could flip the entire Second Amendment fight on its head. Overnight. Imagine waking up tomorrow to realize your state's power to protect your gun rights might no longer exist, not because of new legislation, but because of a single Supreme Court order that almost nobody saw coming. This isn't speculation. This is breaking legal history. And if you care even a little bit about the Second Amendment, what I'm about to reveal could change how you see the balance of power between states, the federal government, and your own rights to bear arms. Before we dive deep into the details that the mainstream media isn't even touching, hit that subscribe button right now and turn on notifications, because this is the story the government doesn't want you to understand. It happened quietly. No fanfare, no massive press conference. Just a short order from the Supreme Court. Relief denied. But that short sentence sent shockwaves through the legal and gun-owning communities nationwide. The ruling, an 8-1 decision, with Justice Clarence Thomas standing completely alone in defense of Missouri's Second Amendment Preservation Act, or SAPA. Now think about that. 8 justices, including the 3 Trump-appointed conservatives, all sided against the state of Missouri's request to protect its gun law from federal interference. That's not just unexpected. That's unprecedented. So the question is, why? Why would the very court that handed down Bruen versus New York, arguably the most powerful pro-gun rights ruling in modern history, suddenly back away from protecting a state's attempt to enforce those same rights? To understand it, we need to step into the strange world of the anti-commandeering doctrine, a constitutional principle that says the federal government can't force states to enforce federal laws. In theory, this doctrine gives states power to refuse participation in federal enforcement efforts. But this new ruling exposes a bizarre paradox, because states can't be forced to help. They also apparently can't refuse to help without risking a federal lawsuit. It's like being told, you don't have to do this, but if you don't, we'll punish you anyway. And this is where things get dangerous, not just for Missouri, but for every state in America that values independence. See, Missouri's SAPA law wasn't just symbolic. It cut off federal access to thousands of local officers, state-run crime labs, and intelligence networks. It sent a message: our officers will not help you enforce unconstitutional gun control. That single act, that defiance, was enough to make Washington panic. Let's talk numbers. The ATF, the federal agency responsible for enforcing gun laws across the country, has around 5,000 agents total. That's it. 5,000. Now compare that to the 800,000 state and local law enforcement officers across America. That's the real muscle behind most gun crime enforcement. So when Missouri passed its Second Amendment Preservation Act, it effectively pulled 14,000 officers off the federal enforcement grid. No more cooperation, no shared databases, no combined raids. Federal prosecution started to crumble, and Washington knew it. According to DOJ internal reports, federal gun crime cases are twice as likely to fail without state assistance. When states pull back, conviction rates collapse from 78% to just 34%. So this isn't about philosophy. It's about control. The federal government simply can't enforce its own gun laws without the states playing along, and Missouri just proved it. Here's the part that absolutely terrified bureaucrats. Missouri's SAPA law didn't just say, don't cooperate. It said any state official who does cooperate with federal agents in enforcing unconstitutional gun laws could face a $50,000 fine. Personally. Not the department. Not the state. Them. Personally. That means a sheriff, a trooper, or even a local clerk who shared ballistic data with the ATF could get sued for $50,000. In just the first year, Missouri's Attorney General got over 340 inquiries from state employees asking if their everyday duties might trigger lawsuits. Think about that level of fear. One trooper put it perfectly. If backing up a federal agent costs me $50,000, I'm out. Law enforcement unions said nearly 1 in 4 officers were considering early retirement over the confusion. The federal government knew if this law spread, if other states copied Missouri's blueprint, it could bring their entire enforcement network to its knees. Now here's where the story gets almost cinematic. You'd expect the Biden administration to oppose Missouri's law, and they did. But what nobody expected was that the Trump Department of Justice took a position that seemed to agree with both sides at once. They said, yes, parts of the law go too far under the Supremacy Clause, but the Biden administration's response was way too extreme. In simple terms, Biden wanted the entire law wiped out. Trump's legal team wanted only small sections blocked so that the rest could stay in place. If that approach wins in district court, 92% of Missouri's protections for gun owners could come back. That's huge. It's a blueprint for every other state that wants to resist federal overreach without triggering a full-scale legal war. Then came the Eighth Circuit Court of Appeals, and what they did defied all logic. They admitted, in their own words, that Missouri's law was constitutionally structured, meaning the design, the process, the way it functioned, all legally valid. And then they struck it down anyway. Why? Because they didn't like the purpose behind it. Protecting Second Amendment rights. That's like saying, you're free to speak, but we don't like what you're saying, so we'll silence you. This isn't how American law is supposed to work. In the past 40 years, only 7 other cases have been struck down this way, and 6 of them were overturned by the Supreme Court. So the question becomes, why did the court let this one stand? And what happens now that it has? Missouri isn't standing alone. At least 12 states, including Kansas, Idaho, Montana, Oklahoma, Tennessee, and Alaska, have introduced or passed similar Second Amendment preservation acts. Together, they represent 47 million Americans and over 118,000 officers who could refuse to help enforce federal gun restrictions. If those states activate their laws, the federal government would need to hire 1,200 new ATF agents, costing around $180 million a year, just to maintain current enforcement levels. And here's where it gets even more interesting. Data shows that after Missouri's law went into effect, gun sales in the state jumped 23% compared to neighboring states. It's not about rebellion, it's about confidence. Gun owners felt safer knowing their state stood between them and Washington. Now that the Supreme Court refused to intervene, the fight moves back to the district court. And that's where things could get really intense. Judge Brian Wimes, who's overseeing the case, now has what's called broad equitable discretion. In plain English, that means he can rewrite the injunction however he sees fit. Line by line, section by section. Missouri's legal team is preparing a 200-page brief, arguing for a surgical approach. Block only the parts that directly interfere with federal criminal prosecutions, and let everything else take effect. If Judge Wimes agrees, it could restore most of the law while staying legally bulletproof. That would make Missouri the first state to legally outmaneuver federal gun control through precise constitutional strategy. So what does all this mean for you? The everyday gun owner watching this right now. It means that the battleground for the Second Amendment has officially shifted. No longer just a federal issue. It's now a state-by-state resistance movement. If states can't protect their citizens from unconstitutional enforcement, the entire foundation of American federalism starts to crumble. This 8-1 decision wasn't just a legal ruling. It was a warning shot. It told every state, your autonomy ends where federal convenience begins. But history shows that when Washington overreaches, states push back harder. And that pushback is coming. So now the question is, if the Supreme Court is willing to deny protection for a law that literally mirrors the Constitution's own text, what happens next time? What happens when another state steps up and says, "No, we will not enforce your rules"? Will the federal government strike them down too? Or are we about to witness the birth of a new wave of constitutional defiance spreading across the country? Because one thing's for sure, the fight for the Second Amendment isn't ending here. It's just entering a far more dangerous, far more unpredictable phase. Drop your thoughts in the comments. Do you think states should have the power to refuse federal enforcement when it comes to gun laws? Or should the feds always have the final say? And if you want to stay ahead of this unfolding story, every new ruling, every new bill, every shift in the legal battlefield, hit that subscribe button right now, turn on all notifications, and join the fight to stay informed. Because the next decision might not just change the law, it might change your rights forever.